I am Dr. AUSAF, your medical legal expert. Today, I have come up with a new topic, that is 4Ds in medical negligence. What is 4Ds in medical negligence? Let's study first what is medical negligence. Failure to follow norms is a negligence. These norms can be case specific, situation specific, or context specific. Medical negligence can also be defined as an act of commission, an act of omission by a doctor invariable in which a patient is harmed. So what is act of commission? Let me give you one example. Amputation of a leg which is not recommended, or leaving an instrument in surgery is an act of commission. Similarly, when a patient is not referred to a higher institute or to an expert in a time, then it is said to be act of omission. So, act of omission plus act of commission is equal to medical negligence. There are 4 essential to know what is about medical negligence. The 4 essentials are, which is known as 4 Ds. Let me tell you one by one. The first D, that is duty to care. When a patient is admitted under your care in IPD, or when he comes to your OPD, it is agreed that you are going to treat the patient by a doctor-patient relationship. This is nothing but a duty to care. The first D. The second D, that is deficiency in a duty. For example, if a patient gets admitted in an IPD in a hospital under your care and you fail to visit him within 24 hours, then this is known as deficiency in the duty. The third D, damage to the patient. Suppose a patient is admitted of a road traffic accident under a consultant, maybe neurophysician, maybe neurosurgeon, or a physician also, and he gets stoned and he dies within 24 hours and he remains unattended by this consultant. So this is directly a damage to a patient. So this is also one of the most important factor to consider a medical negligence. This is the third D. Okay. The fourth D, that is damage occurred as a direct consequence of the act by the doctor. This can be physical or mental or a financial loss to a patient or a relative. So to sue any doctor, these 4 Ds are essential. That is duty to care, deficiency in duty, damage occurred to a patient, damage as a consequence of the act. So these 4 Ds are most important thing. This comes under civil negligence, which comes under law of torts. There are many more types of negligence. The other type is criminal negligence, which is found rarely, unfortunately, which is a sort of a gross negligence. For example, doing a surgery on a wrong person or amputating a wrong leg is a classic example of criminal negligence, which is a gross negligence. The other type of negligence is contributory negligence, where the doctor as well as the patient is responsible for the negligence. The another type of negligence is composite negligence, where one or the more than one doctor is involved in the negligence. Corporate negligence is another type where the hospital management is involved. So these are the other types of negligence where the doctors are sued under medical negligence. But the most common is the civil negligence, where we have seen 4 Ds. Now, on what basis does a court give the judgment in the favor or against the doctor through a medical negligence? The basic principle of the medical negligence lies in the Boehm's test. So what is this Boehm test? Boehm test has been derived from the landmark judgment by the Justice McNair in Boehm versus Prime Hospital Management Committee in 1956. 7. In 1954, Mr. John Hector Bolam was undergoing ECT therapy in the Friar Hospital Management Committee's Health Institute, and in that ECT, the first cycle went smoothly, though Mr. Bolam had given consent for this therapy. The second cycle of ECT, that is electroconvulsive therapy, caused him some sort of injury, and it caused him a sort of fracture. Then later on, Bolam sued the hospital for compensation, but Justice Mr. McNair gave the judgment in favor of the hospital. So this was known as Bolam's test. So Mr. McNair, the justice at that time, he gave the statement which I will try to read and tell you. The statement was, where you get a situation which involves the use of some special skill or competence, then the test as to whether there has been negligence or not is not the test of the man on a Clapham omnibus, because he has got this special skill. The test is the standard of an ordinary skilled man exercising and professing to have that special skill. The man need not possesses the highest expert skill. I would like to repeat this statement. The man need not possesses the highest expert skill. It is well established law that it is sufficient that if he exercises the ordinary skill of an ordinary competent man exercising that particular art. This is a judgment of the court by Justice McNair. This has not been told by me. It is the judgment basically, which you can see through the slide which is next to me. In short, the Bolam test states that if a doctor reaches the standard of responsible body of medical opinion, he is not negligent even if some specialists hold a contrary opinion. So my dear colleague, this is all about medical negligence in short. So do care without fear. And remember, you don't have to give the service to the patient at a very high level. It should be on an ordinary and a standard level. You should follow the norms which has been laid by the respective body, the respective council, and always remember one thing: be alert and be aware. And remember one thing: protection, prevention, and prudence is better than prosecution. Thank you very much.